I think we are ready to go. My name's Cheryl Lawther. I'm a member staff here in the School of Law at Queen's, and I'm chairing this afternoon's proceedings. It's my pleasure to welcome those of you who are here in the room and those of you who are joining us online to the launch of this report, More Than a Number, Reparations for Those Bereaved During the Troubles in Northern Ireland. This report has been written by my colleagues, Professor Moffett and Dr. Kevin Hearty, who will be joining us shortly. Of course, this report comes at an extremely timely juncture while there's considerable media pressure, political scrutiny, and work amongst civil society more broadly as regards dealing with the past in Northern Ireland and indeed the failure to deal with the past. As we all know, those who were bereaved during the conflict received little to no compensation, particularly in the early years of the conflict. And indeed, some of those amounts of compensation were derisory and insulting to many victims and survivors. So this report comes at an extremely timely moment. As Ian will explain later on, it also fits into a broader pattern of work that the Commission for Victims and Survivors is doing as regards the needs of the bereaved more broadly. So I very much welcome the publication of this report and commend my colleagues on their work. In terms of the programme for this afternoon, I'm shortly going to hand over to Luke to take you through some of the key aspects of the report. Dr. Kevin Hearty will join us and do the same with the particular areas of interest and expertise that he has. And then I'll hand over to the Commissioner for Victims and Survivors, Mr. Ian Jeffers, for his comments and reflections. After that, we'll have a period of about 20 to 30 minutes for question and answer. Now, of course, the question and answer session is not restricted to those of you here in the room. We do have about 15 participants online. So please, if you're joining us online, please feel free to use the chat function and we'll try to get to your questions as best as we possibly can. So thank you all again for your attendance today and the importance that you're awarding to this report. I'd like to hand over to Professor Moffett. Thank you.
Thank you, Cheryl, and thank you for Declan, Richard, and a whole host of people who helped us to get here, especially those from the compensation services, trying to show me through how to navigate the different the data set that we're looking at. Now, this project is the very end of a project we've been doing for about over 5 years. It finished really in August last year, but we felt that the issue of the bereaved was something that was raised by victims as we interviewed them from over the past 5-10 years, and something which we needed hard data to sort of explore to what extent were bereaved people, bereaved families had some sort of reparations. And really, the project itself was on reparations. It's a difficult subject to talk about in Northern Ireland. It's almost like a dirty word, but we talk often about truth and justice, and yet in international law, it's truth, justice, reparations, and non-recurrence. And so what we really want to do is for a long time, we've been trying to bring reparations back into the common vocabulary of how we do things in the past, because reparations aren't just about money. Money helps, but it's also about the individual acknowledgement, because we recognize, having worked in over a dozen post-conflict countries, is that there's not going to be the complete truth. Not every perpetrator is going to be prosecuted, but reparations are victim-focused measures as a way to sort of acknowledge what they've suffered, but also as a means to help them move forward and their families. So really, the project itself has this data set. Now, it's taken us a long time to get here. COVID interrupted it because it was difficult to get into Peroni. You can only do 10 records at a time. And we were dealing with tens of thousands of applications. It's not simply in one folder. We're talking about every county court having thousands of documents. It's very literally dry work, the amount of paperwork, but it's also quite sad in a sense, because you've got people's lives and you've got thousands of claims for property, injury, and death. And so we were trying to distill down through all this paperwork to try to identify cases where people were killed and how much they were compensated. Now, in the report, we go into more detail about the methodology and what data we got. I think with the help of the compensation service and DOJ, we were able to get a bigger capture of data for those being compensated. The thing is, we couldn't do it all. It would take us another 2 years to really capture fully all the data. And also the data set's never going to be complete, because some people didn't claim, some people didn't claim in Northern Ireland. And so what we tried to do was get up to the 1,000 cases, so we could have some sort of reliability. And we focus on 1966 to 1976. I know a lot of people think Troubles started in 1969, but there's 3 murders, Troubles related in 1966. And up until this period, half of the people who were killed during the Troubles died, as you probably all well know. But it's also before the law changed. And this might seem like, oh, things after 1977 got better. To some extent they did, and on one ground they did. Widows got a guaranteed discretionary payment of up to £5,000. In 1982, that went up to 10,000. For other family members, including those who lost a child, they wouldn't get that money until 1988. And for anybody else, there wasn't a bereaved payment put in place until 2002. And none of this stuff applied to anything that happened before. So the reason why the change happened in 2002 is because Kenneth Bloomfield, the former Victims Commissioner, said bereaved families need to be properly compensated and need some sort of support for their suffering. But it was never backdated and never applied to anybody who suffered before 2002. So what we wanted to do was sort of interrogate a lot of what we were hearing from bereaved families, that what they've been compensated in the past was a pittance, was a slap in the face. Some people talked about how when their family received the money, it was £150, £250, £1,000. They saw it as blood money. They saw it as something that they couldn't touch. It was like, it was toxic, because how could they get this amount of money for their loved one? So it's very difficult for them to deal with. We also don't talk about individuals. The report is more than a number, but we don't talk about personal stories, because it is incredibly personal to talk about money for a family member. So we're trying to be sensitive to that. And I think the data speaks quite strongly about what we have found. So the data set itself, you'll see there, this is all the claims, and I'm not great at graphs, so this is the best I come up with. But effectively what you're seeing here is the vast majority of claims are under 60,000. And when you go into that in more depth, this £5,000 a month that was £5,000 that was established in 1977 onwards, the vast majority of victims before 1977 got less than this. And it's not just civilians, it was also those who are widows in the security forces, because the calculations of how much their pension was often subtracted from how much they were going to earn. Now, we're not trying to say that the system was somehow broken. It was based on quite a reasonable system that was first designed in New Zealand, trying to be more victim-centred and making sure that the victim didn't have the burden of the crime. It was adopted in England and Wales. Ireland has always had some sort of compensation scheme for crime for about well over 1,000 years. But the scheme changed in 1968, the year before the Troubles came in, to bring it in line with other developments that were happening in England and Wales. The thing is, a lot of the violence that happened in Northern Ireland wasn't ordinary crime like we'd have in New Zealand. It was mass violence. That meant that people were unemployed, people were displaced. And so basing reparations just on a person's income and earnings did a great disservice, because for people who were single, for women, for those who were cohabitees, they got next to nothing. And we'll go through the data to sort of show that. So it was very much you had to show what the person was earning. And that meant massive discrepancies. We've got a number of cases where somebody was paid £50 in a bombing who died, and another person who was killed got 15,000. Same day, same incident, same place. In other cases, you've got the same family members who are killed. One's given £92 or £100, and another's given 15,000 or 5,000. So big, massive discrepancies in these cases. And it's quite understandable how these came about, because the scheme was set up based on, were you dependent on this person's income, and what was that earnings? For anything else, and so the lower awards were for funeral expenses, where you couldn't show dependence on the person's income. And so we've got just horror stories of how the legal system, how judges and lawyers didn't really best represent or do justice to victims, where they've got cases of judges saying to somebody who's recently married, well, you were still living at home with your parents, you weren't dependent on your husband who was killed, even though you're married for 9 weeks. Or you've got cases of, she was 20 years old, she would have got married at some point and left the family home, so you're only getting funeral costs. And so what we found was that it was a real disservice to victims. It was inadequate. It didn't, what we would talk about in human rights law, redress and give compensation for non-pecuniary harm. And non-pecuniary harm is stuff that you can't give a market value to, a monetary value. And so in human rights law, you would give compensation for people who suffer from the harm itself, from the violation, for suffering, for the fact that they've suffered these really serious crimes. And that didn't happen under this law. The bereavement payments that sort of came then later tried to do this, but it wasn't built into this past scheme. And as a result, there was a hierarchy on who was compensated and how much. And that very much plays out in terms of the payments here. Now, if Kenneth Broomfield's reports in 1998, we will remember them, talks about there's tens of millions that were paid in compensation, particularly for those who are bereaved, and used the word it was generous. There's a sentiment that was generous to victims. What we've found in the 1,000 cases that we've identified is that for 1,000 people, there was less than 7 million paid. And some of those cases, 2 or 3 of them had over 100,000. So that left the average of person being paid around £6,900. For women, it was about less than £2,000 on average. So already this gender dimension plays a big part in terms of the, sorry, we've lost the track of the gender. So in terms of the gender, women, majority, so if you think that the average was about here, women were getting well below the average. And these sort of other outlier cases is where women were working in an office job, or one of them was in the UDR. So there was higher payments, but this were on average far lower than any man. And so there's a number of cases where a man is killed in the same instance as a woman, and the woman gets, their family gets just maybe £90, £100 just to bury her, and the man gets thousands of pounds. And it's because the scheme was based on income independence. It's a simple way of sort of compensating, and it's still used in many places today. What we suggest needs to be used is some sort of bereavement scheme. We've been through these arguments for years. Victims, as you well know, aren't getting any younger, and none of us are, but we need to deal with a scheme that can properly acknowledge the loss that's occurred. Now, we don't need to go over the arguments of the consultative group, the past, and the recognition payments about who's going to get it and who's eligible. We can work through those issues. The Victims Payment Board already does, the injured scheme. But we need to think about how it's going to work and how it's going to be paid. And there's a whole range of schemes. So in the report itself, we go through different options. We also talk about thinking more broadly than just the spouse of the child. We think about, how would it work in different ways? Should siblings be eligible? Should parents particularly be eligible where they lost a child? And how much should each get? So there's different options. What we're trying to do with this report is to set out the case of it was unfair, it was not fit for purpose, and also then how we can move forward. And so there's policy options there. I would like to say that this is all completely new, but former colleagues here, Desmond Greer and Valerie Mitchell, wrote a report in 1976 and 1977 on the compensation scheme of 1968, saying that this scheme isn't made for, it's made for ordinary crimes, and Northern Ireland, what it suffered in those first 10 years was not ordinary crime. Now, they didn't have the data that we had, but they're already pointing out in 1976 that the scheme wasn't fit for purpose. And the reason why changed amendments came is because war widows put a lot of pressure in the media and on Parliament to slowly change things and improve things for widows. They got a dedicated discretionary payment for widows. Other victims were by themselves. They had to rely on support of family or their community. There was no place to turn. There was no real victims groups until the 90s. And so there was none of that solidarity that maybe those in security forces had. And it's not saying it was easier, because those who in the security forces had their compensation reduced because of their pension, but the system wasn't fair in so many different ways. And victims were made to feel like single cases. And also, and Kevin will speak about this, it's the inequality of bargaining power, that for victims, you sometimes just have to accept what you got because you had bills to pay after the death of the breadwinner. So I'm going to leave it there, but we'll have plenty of time for questions, and there's copies of the reports here if you haven't got one already, and it's also available on our website. I'm now going to try and get your slides. If you want to copy, Kevin.
So compensation schemes for conflict-related bereavement are, we are told, premised on providing acknowledgement of victim survivors and mitigating any resultant material harms that bereavement causes. Whenever we sat down a few years ago to critically examine statutory compensation for conflict-related bereavement, with an inkling that it probably wasn't going to be a good news story. However, if I'm being frank and completely honest, I'm not sure that anybody on the team back then truly appreciated how utterly abysmal the system would transpire to be in failing to meet that core criteria. While much recent discussion has rightly been on criticising the UK government's Legacy Act, our report suggests that the Legacy Act is simply the latest manifestation of the contempt shown towards and lack of consideration afforded to victims and survivors that stretches back decades. The picture that emerges from within our report is of a compensation system that seemed more concerned with shortchanging victims, testing their resolve for prolonged legal action, and closing off avenues for legal accountability than it was with affording victims and survivors acknowledgement and meeting their material needs. So this afternoon, I'm going to briefly outline some of the main thematic findings of our report, highlighting the patterns of gendered, age, and class-based inequality that pervaded within the system. So one of the most significant factors that influenced compensation was the income of the deceased. Now, in the context of a conflict where most of those killed were working class people from socio-economically deprived areas, basing compensation on income rather than on acknowledgement and or need naturally placed a significant number of families at a distinct disadvantage. For example, the widow of a leading cancer specialist killed in a 1975 IRA bomb in London was awarded £40,000 compensation. This payment, along with the proceeds of the sale of the family home after she decided to downgrade, allowed her, in her own words, to secure her children's financial future. Now, by contrast, families whose loved ones were employed in poorly paid manual labour jobs, or who were temporarily laid off work, or who were in receipt of other state benefits received far less generosity, regardless of the size of their family or the urgency of their need. In fact, in approximately a third of the cases we examined, families were awarded less than £1,500. For example, the widow of a man killed by the British Army in 1971 was awarded £350 compensation for herself and her 9 children. In total, not each. Most problematically, the case heard prior to this had seen the owner of a prized greyhound being awarded £700. Similarly, a widowed mother of 12 was informed that because her husband was on sick benefit when he was killed, she was now actually £1 a week better off on a state widow's pension. And this woman was subsequently sent away without any further payment. In other cases, compensation payments offset benefit payments that victims' families were otherwise entitled to. We can see then that basing awards primarily on income rather than on acknowledgement and need allowed inconsistency and inequality to pervade the statutory system as hierarchies of material worth clearly emerged. Gender was also relevant on 2 grounds: the systematic undervaluing of the lives of women and how families struggle to cope with financial hardship following bereavement. And this reflects how even though women account for around 10% of those killed within the sample time frame of our report, they were nevertheless the main claimants of compensation. So the natural result of basing the system purely on income rather than need was that unpaid work within the family home was often looked on much less favourably than paid employment. And this obviously placed the families of women victims at a disadvantage. It is perhaps unsurprising then that of the 90 cases involving women victims within our sample, a third received less than £150 and more than half were awarded less than £1,000. Now, although the NIO made some attempt to address the gender gap in 1975, the following remarks from the husband of an Oma bomb victim suggest that inequality still pervaded within the system. And he said because she was a housewife, she had no monetary value, as opposed to someone who worked 80 hours a week. She looked after her children. She was their mother. If she had been a solicitor or a teacher, they would have given money out from she was 39 years old until she was 65 years old for what she would have earned. But because she was a housewife, she was treated like garbage. The compensatory system also overlooked the gender dimension of conflict-related bereavement, whereby women often had to assume the role of breadwinner and primary caregiver within the family and try to strike a delicate balance in what is really an impossible balancing act. Now, the reality of this was captured by one victim whose mother was awarded £12,000 following the killing of their father. They said, "My mother had to bring up 2 children and had to give up work. She was bad with her nerves and had post-traumatic stress disorder after being shot at herself. The whole thing took a toll on her. That money that she got was ludicrous. Life was very difficult for us growing up. We had no money. We lived for my mother's widow's pension coming in every week, and we didn't have a fridge until I was 11 years old. Now, not only was such a reality ignored within the system, but on other occasions, it was compounded by crass insensitivity and bureaucracy. In one nakedly sexist example, a young widow was told by the judge that she was a young, attractive woman who could marry again. In another example, a widow who had been awarded £400 had £350 deducted for rent arrears and a further £50 deducted for electricity, essentially leaving her with nothing. There were, as the report further states, additional barriers that disadvantaged unmarried mothers, cohabitees, and common law partners. So through the systematic undervaluing of female life, overlooking the longer-term familial impact of bereavement, and procedurally enforcing patriarchal norms around marriage, it is evident that the compensatory system operated to a gendered logic that disadvantaged the families of women victims. Likewise, the requirement to show dependency on the deceased disadvantaged the families of children and young people. Hence, the family of 3 children who were killed when an IRA getaway vehicle veered out of control in 1976 had a claim for an unspecified sum for the loss of their children refused. They were informed at this time that they were only entitled to funeral expenses. A subsequent compensation offer of £3,500 from the NIO in 1977 was rejected by the family, with their mother commenting that, "I am utterly disgusted with the offer and I'm obviously going to fight it. I have broken up my home, lost my children, and they have the cheek to offer me £3,500. In other cases, awards as low as £56 for child victims have been recorded, while in another astonishing case, the parents of a child were offered more in compensation for their child's clothing being destroyed in a bomb attack than was assigned for funeral expenses. So within a system premised on income independency, a tension clearly exists between sufficiently recognising the human aspect that the loss of a child in such circumstances can be particularly devastating with, from the bureaucratic perspective at least, some acceptance that they were not economically active nor had they dependents. Further friction is also evident in how the cold and detached bureaucratic way of seeing the child victim as they were at the time of their death fails to correspond with the tendency of families to see the unmet potential inherent in the child. Yet this problem was not exclusive to child victims. It disadvantaged the families of younger victims more generally. Now, naturally, younger victims were less likely to have been married, to have had children, to have family dependent on them, or to have established professional careers. So often this meant that families were offered little more than funeral expenses. Accordingly, our sample shows that the families of victims under 25 were, on average, offered less than half of the average award paid out to the sample as a whole. And this problem is perhaps best captured in the case where a compensation award of £1,582 initially made to the family of a university student was subsequently reduced to funeral costs of just £82, owing to the fact that his parents were not dependent on his income. Whether or not victims had access to legal representation was also a significant factor. This reflects a disturbing trend of trying to hardball victims with derisory offers, working on the assumption that victims would accept rather than legally contest these offers. In such situations, victims were faced with the choice to either accept a derisory offer or reject it, with a view to then renegotiating with the NIO or contesting the case in court. Low offers were accepted in many cases because victims and survivors were often unaware of their rights, or they were in dire financial straits, or they did not have access to the necessary legal representation advising them against acceptance. For others, acceptance meant avoiding the added trauma of a long, drawn-out legal process or court case. As Kenneth Bloomfield noted, a critical moment comes when an applicant has to decide whether to accept an offer made to him or her. Some felt that they had faced an invidious choice between acceptance of an unsatisfactory award and the consequences of further delay, perhaps leading to a court appearance and the prospect of adversarial cross-examination. Where victims and survivors could afford and/or access legal advice, contesting initial offers tended to result in an improved offer then being made. There is, too, a belief among some victims of state violence that compensation was used by the Ministry of Defence to deflect bad publicity of the security forces and to foreclose legal accountability via the criminal justice system. And one of the most notable examples on this front is an award of £37,000 being belatedly made without acceptance of liability in order to terminate a case that had proceeded to the European Commission. So in conclusion then, in light of this litany of obvious shortcomings, the report concludes that conflict-related bereavement needs to be revisited today as a matter of import, all the more so in light of recent attempts to shut off avenues of civil litigation for victims and survivors. Any system that valued the life of a greyhound as twice that of a working class father and husband, or that seen remarriage as a solution for the financial difficulties faced by young widows, or that believed that the clothes worn by a child were more valuable than the life of that child itself, clearly failed miserably in providing acknowledgement to families and fell considerably short of protecting their material interests. So what we propose in this report is an admittedly belated, yet nevertheless necessary, corrective to what can only be seen as a previous system characterised by sexism, ageism, classism. Thank you.
Thank you very much, Kevin. We've heard some very powerful evidence this morning coming from the archives and from the work of our colleagues. I'd now like to hand over to the Victims Commissioner, Ian Jeffers, for his thoughts and reflections. Ian.
Thank you very much, and thanks for this opportunity to say a few words. Can I start off by congratulating Luke, Kevin, and the entire team for producing what is a very timely report. You talked, Kevin, about the need of being a little late, but I think there can never be a more important time to get this report out. This morning I was asked if I was surprised by the findings, and the truth of the matter is I wasn't surprised. Maybe it's because I've listened to Luke patiently as he describes it over the last year, but also, as many of you know in this room, when you talk to and you meet victims and survivors all the time, you know the pain and suffering that they're going through and how we have failed as a society to recognise some of that. I was interviewed as well by Mark Simpson on Good Morning Ulster, and he said, "Oh, I've lost count of the number of times you've been in here." Now, I've only been in post about a year, so that to me indicates that we're failing victims and survivors. If I have to continually go on the radio to highlight the inadequacies of what we're doing for victims and survivors, 25 years on after the Belfast Good Friday Agreement. If we're leaving it to really academics to try and shed light on potential next steps for reconciliation, I think we've got to challenge ourselves as a group of what we are really doing. Luke and Kevin have talked about some really bold examples, specific examples. And if you read through the report, you will see, the mum who received £120 for the murder of her two sons, or the father that got £43 when his daughter was killed. These are really painful things to reflect on, but we need, unfortunately, to use them to highlight these woeful awards and to use this report to challenge the current situation, because we can't continue as it is. Way back before I joined the Commission, actually in 2012, they commissioned a huge piece of research that identified 4 pillars that looked at what was about addressing the needs of victims and survivors in a post-conflict setting. And no surprise to any of you here, it's truth, justice, acknowledgement, and reparations. And if we were to ask ourselves, how much have we done in the years going forward, I'm not sure any of us can really be totally proud of the answers. We've made progress, but not sufficient progress. Now, I firmly believe part of the reconciliation journey is to acknowledge the pain and suffering that families and communities have endured, and in many cases continue to endure. Government has, as we know, as of Monday, with the royal assent of the Northern Ireland Troubles, Legacy and Reconciliation Bill, we give it its full title, effectively terminated legal avenues for victims, survivors and their families to seek redress. Court cases, as we know, started 10 o'clock this morning in the High Court to challenge the Act. But the cruelty is that these will take time. I was told on Monday that they suspect it could take 6 years for some of those cases to come to fruition. The very system that the Secretary of State says will provide answers and reconciliation for victims and survivors is forcing them into court to fight for basic human rights. What civilized country forces victims that have been through hell into a court to challenge an act of Parliament that is closing the right of an inquest or giving a perpetrator immunity in exchange for information? So we've got to reflect on how we actually move forward now that the ICRIR, and you'll hear it called ICRA as they shorten it, because none of us, I certainly can't say ICRIR that often, but now it comes into being and what that actually means for us all. But we shouldn't ignore the past, and what indeed today's report provides us with is that opportunity to reflect on some of the unfinished business of the Troubles. Because even if the government believes the launch of ICRA and the movement of this bill to become an act draws a line under things, it doesn't. We have unfinished business that needs addressed. Luke and the team have highlighted the significant area that needs to be addressed, and this report provides the hard evidence that makes it impossible, I believe, for policymakers to ignore. It's very easy for all of us, or for any of us, to knock the door in Secretary of State and say, I want to listen to this, that, or the other about a specific incident. But the report provides hard evidence, hard researched evidence of over 1,000 individual cases that cannot be ignored. The rollout of the Victims Payment Scheme has in many ways highlighted the inadequacy of the current scheme for the bereaved, and we do need to challenge this. Now, the Commission in our role is preparing an advice paper for government on this very issue. And again, it's thanks to the team here at Queen's that we've now been given that research and the evidence that will significantly enhance our advice. But of course, the elephant in the room will come down to who gets what. I think you've touched on it a little bit, Kevin. Robin Eames and Dennis Bradley know full well the challenge of recommending a one-off payment to people who have been bereaved. And while my office must work within the definition of victims as defined by the 2006 order, I would not want that to be an excuse to do nothing. Workarounds were found for the Victims Payment Scheme, and while it may not be perfect, we can at least say we have a scheme that acknowledges those that have been severely injured. But that scheme took 13 years of campaigning before it was delivered. And we cannot accept or expect or indeed tolerate another campaign potentially led by victims to deliver an improved scheme for the bereaved. We've got to do something a lot quicker. So the Commission will further engage with key stakeholders over the next couple of weeks, actually, as we finalise our paper for government. And then within the next couple of months, I'll issue that advice to government at a local and a national level. And I, together with, I think, many of you in this room, will hopefully attempt to get a speedy solution to this challenge. On Monday, the Secretary of State said, as the bill passed into becoming an act, the Secretary of State said he wanted to build a legacy process founded on integrity, expertise, and fairness. That was his words, not mine. Legacy process founded in integrity, expertise, and fairness. The courts, unfortunately, will now decide much of that over the coming months and years. But my simple call to the Secretary of State is that if he genuinely wants a legacy process that is built on fairness, now is the time to address the issue of the bereaved and create a system that is equitable and acknowledges the loss of so many families across Northern Ireland and beyond. So once again, sincere thanks to Kevin and Luke, and to the many people, the academics, the government officials, the community representatives, the countless other people who have stepped into this space in the hope of contributing to a better future for victims and survivors. It is important that all of us continue to do this challenging work, that we step into uncomfortable spaces, that we put our heads together and we find solutions that work. And we do this time and time again so we don't pass it on to future generations. So the last thing I want to do is turn on the radio in 10 years' time and hear another commissioner going on about what we haven't done for victims and survivors. As a society, we've been through a heck of a lot together, and we deserve for our victims and survivors to do a lot more for them sooner rather than later. So thank you for attending today. And again, I commend this report from Queen's University. Thank you.